Well, thank you so much for having me. I'm pleased to be here. My name is Nicole Wemhoff. I am an attorney at Arnall Golden Gregory, based in the Washington, D.C. office. I work in our healthcare and life sciences practice group, as well as our litigation practice group. And my practice focuses on provider reimbursement of all types. But I've spent a lot of time working with the SUD provider group specifically, and have spent a great amount of time working with 42 CFR Part 2 to address a number of healthcare challenges with data sharing that this community has faced, and data use agreements, responding to subpoenas. Kind of had a great leeway, requesting all records requests. I've handled a lot of those in my time as an attorney. But we're here today to talk about 42 CFR Part 2. There has been a lot of changes in the last 5 years in particular, but I think some of the ones coming up could be the most impactful yet. And so the CARES Act made some changes, and so they finally got around to releasing some proposed rules. So that's what I would like to talk to you guys today about. All right, so today I'm going to go through a brief summary of 42 CFR Part 2, outline the changes that the CARES Act made to the underlying law, and then kind of describe how the recent SAMHSA regulations are going to potentially change the landscape, and how we may need to kind of help providers kind of come along and keep up to date with what's going on. And then kind of also identify where they may need further guidance down the road, and kind of some of the potential issues that we may see as the regulations are implemented. Okay, so for some background, 42 CFR Part 2, or Part 2, was originally enacted in the 1970s and remained substantially unchanged from 1987 to 2017. The law was originally enacted and continues to be to reduce stigma and bias associated with substance use and having, an illicit drug problem, which was a very hot button topic in the 70s and 80s. But what was originally designed to prevent stigma and keep those patients' records confidential ultimately created care silos, hinders quality medical care, and perpetuates the stigma in an era of electronic health records, health information exchanges, as we just kind of briefly touched on, behavioral health integration, and conflicts with HIPAA privacy protections, which were enacted in the 1990s and have been further updated in the early and mid 2000s. The ultimate and kind of original goal of 42 CFR Part 2 was to create consent as the touch point for the sharing of records. But as we know, that patients may not always be compliant, and those very strict and rigid requirements without lenient exceptions really puts a burden on providers and the entities that they contract with to accomplish their business. It puts them in a tough way and really creates those care silos. As some additional background, just to kind of create a touch point, wanted to kind of create a framework for how 42 CFR Part 2 really attaches to records and when it applies to programs. We kind of know that from a HIPAA perspective, it really is the type of provider, and if you receive electronic transactions, that's kind of how you get. There's certainly a covered entity analysis, but with Part 2, it's a little bit more nuanced, and it really attaches to how you get funding and a very more complex definition. So 42 CFR Part 2 applies to all records relating to the identity, diagnosis, prognosis, or treatment of any patient in a substance use disorder treatment program that is conducted, regulated, or directly or indirectly assisted by any department or agency of the United States. Very complex, a lot of words. I'm so sorry. But with patient identifying information, it's a little bit more nuanced than what we see with PHI, because it's what could identify them as having been diagnosed with, referred for treatment. And so while just a provider name may not necessarily attach for a HIPAA, obviously, if you go get treatment at Nicole Wemhoff's drug and alcohol treatment facility and your name is attached to it, that's like very clearly, or like you. So we just have to be a little bit more aware of how, like even branding and how some of those things can sometimes be a little bit more nuanced in this setting. And so kind of going back, originally we were kind of just touching on this and what the definition of a program is. So an individual or entity must be federally assisted, hold itself out as providing, and provide substance use disorder treatment, diagnosis, or referral for treatment. And so all of these kind of underlying words are, important pieces of the analysis. And so it's important to remember that not all substance use disorder treatment programs are going to be subject to 42 CFR Part 2. There's certainly exceptions, and there's certainly reasons why some groups may not want to be associated with 42 CFR Part 2, because it does have strict requirements. And once you are a program, then you are subject to some very strict compliance requirements. And so particularly when we look at the program, or like the provider, so an individual or entity, so those are your standalone groups or facilities that are providing diagnosis, treatment, or referral for treatment. Sometimes you might have an identified unit in a general medical facility, such as a hospital, that is providing, a psychiatric component or a medical detox. That would be something that would be considered a program, or the provider of those types of treatment. Or even just, it could be an identified individual at a hospital or a general medical facility who holds themselves out as providing this type of treatment. And then kind of moving on into our next, what is holding oneself out? That's just such that anyone would be able to reasonably conclude that the individual provides that treatment. And that's something that gets hashed one way or another very frequently in an analysis of whether someone needs to comply with the 42 CFR Part 2 regulations. So certainly that's a very fact-intensive inquiry that would need some more analysis. But I think importantly, it's not just your classic ER physician that's referring someone to a detox unit of a hospital, unless they are, labeled as being that type of a person or individual. And finally, this kind of definition of federally assisted. What does that mean? So I think that the license or authorization granted by a U.S. department or agency, certainly I wouldn't necessarily interpret this as being any state license requires you to have meet this definition of federally assisted. But some providers, not all, could potentially have the Medicare license to provide some level of PHP therapies, or an OTP potentially may get you to that license requirements. But certainly a Medicaid provider would be supported by funds. If they're tax exempt, sometimes we also see that as having been part of that component. Or yes, but as I kind of touched on earlier, some state agencies may require compliance with 42 CFR Part 2 for licensure purposes. So even if they may not be meeting the definition of Part 2, if they're just accepting commercial insurance, they don't, or they are strictly private pay, they may still be subject to Part 2 just based on how the state licenses their programs to provide services at all. So now that we kind of have a framework for how Part 2 attaches to a program, and what records are protected. Moving on to moving on just to a brief discussion about how Part 2 is really designed to create limited data sharing without consent. So, as having the touchstone of consent does create some problems, but we've seen over the last several years an expanded amount of exceptions which allow for data sharing in limited circumstances to accomplish the needs of the program and some other limited reporting requirements, such as in the past we've seen some facilities that might have multiple arms. They might have a program component, they might have a medical component or a housing requirement, and so there are abilities to share within a program about the patient. You're not going to be limited for the purpose of treating the patient from doing that, but certainly not everyone in those types of entities need to have access to every piece of information about every client. Similarly, communications with qualified service organizations, which are outside organizations that provide services to the program, dosage preparation, lab analysis. This is similar to a business associate relationship, and some business associates may be qualified service organizations, but that's something that the proposed rule is seeking to kind of align those two definitions. Just briefly, research activities, audit and evaluation activities, reporting suspected abuse, and in response to a valid court order. Court orders are one that tends to be tricky because courts don't necessarily comply with the strict requirements of Part 2. So certainly if a facility is getting a court order, I think it's always helpful to have, someone that is very familiar with Part 2 reviewing those, just because typically the courts don't know the distinction between HIPAA and Part 2 and how certainly the strict stigma that attaches with drug and alcohol substance use treatment can impact the judicial system. And so we always encourage facilities to have those types of requests reviewed. Consent requirements are very explicit under Part 2. There's kind of 10 major requirements that each have their own individual analyses. There's been some flexibilities added prior to the recent legal changes, but this is certainly an area that is still a touch point for Part 2. One of the biggest changes in recent history from 2017 is the inclusion of the general designation, which allows providers to disclose information, or allows the patient, to have information exchanged to all future categories of treating providers, which eliminates the need to have an individual consent every time they need to have records for that treatment purpose. That's really a major change, just considering that previously you always needed to have a specific individual or organization listed to be able to share that information. All right. The CARES Act in 2020 really set off a very major change to Part 2 because it will have major impacts on a number of areas, including treatment payment and healthcare operation and consent requirements. It also includes much more breach and reporting requirements, and it has several additional patient rights, which are going to be added. Section 3221 of the CARES Act updated the underlying statute and required HHS to publish regulations to bring this into alignment with HIPAA and with the statute. This was supposed to come out before March 27th of 2021, but they didn't really get around to that until December of last year. So we're working slowly, but I think that they took their time to put forth a rule that could actually make meaningful changes to the regulations. I think that there's certainly still some work to be done, but this is a step in the right direction. Some of these changes I'm going to frame in relation to HIPAA, just because that's how frequently providers are forced to reckon with some of these disclosures and treat these kind of actions. Obviously, the SUD providers that are subject to Part 2 need to follow the more strict requirements, and typically Part 2 has been those, and so they've really been forced to kind of straddle the lines, and certainly not all providers know that they're subject to Part 2. I think that that's a very common occurrence in my kind of practice. They understand HIPAA. HIPAA is very common, but Part 2 is not always front of mind. And so the alignments that they're making or seeking to make with this change is something that, could really be positive, because, they're actually going to be complying with the requirements. But I think certainly they may be not aware of some of these changes and how they're going to impact them. The treatment payment healthcare operations are something that has been inconsistent with HIPAA in the past. So unlike HIPAA, Part 2 requires a patient's consent for treatment payment and healthcare operations activities. So, even just to disclose to their billing company, that would require a consent, because it's not, the interagency sharing of data. It's really important for the providers to get these consents on admission. And I think that that's something that they don't always think about obtaining just for, their general operations. And so that's certainly something that I always try to educate providers on when they are kind of coming to us and reviewing consents. That's a very common practice, but, they think about it just for sharing information, that the patient wants, but it's really needs to be a little bit broader. But positively, the proposed rule tries to align HIPAA and Part 2 to a certain extent by allowing a patient to sign one consent and allowing for future disclosure consistent with that original consent. So the proposed rule authorizes redisclosures of patient records by recipients in kind of 3 circumstances. If they're disclosed for TPO activities to a Part 2 program, covered entity, or business associate, the recipient may further use or disclose the records as permitted under HIPAA. If records are disclosed to a Part 2 program that is not a covered entity or business associate, the recipient may further use or disclose the records consistent with the initial patient consent. And if records are disclosed to a lawful holder that is not a covered entity or business associate, the lawful holder may further use or disclose the records for payment or healthcare operations purposes to its contractors, subcontractors, or legal representatives. So that redisclosure piece is going to be very important going forward. It's really going to limit the needs for multiple consents. Previously, I've seen a provider with up to 20 different consents trying to just accomplish their business purposes, which, every time you get a new one, you just create a new form to, keep responding to the next problem. And lo and behold, then you end up with just like a packet of papers that the patient doesn't know what to do with. And you miss one, and it's the most important one. And so it just creates a lot of paperwork. And certainly in the ages of EHRs where they're signing, a form, it's not necessary. Like, you can't click out of it, but certainly you're just making a administrative nightmare for yourself and everyone down the road. So I think this change is going to be very impactful on that going forward. Notably, on the bottom, I just have a quick note that the elements of a written patient consent will be aligned with the content requirements for a valid HIPAA authorization, which just includes a little note that states that they're not subject to, they cannot refuse treatment if they don't sign the consent, except for like very limited circumstances. So this is going to kind of help limiting the need to segregate records or have patients sign more restrictive consents than they were necessarily previously subject to. All right. The breach notification provisions of the regulatory changes are something that's going to be pretty impactful, because previously Part 2 programs and lawful holders were not required to have breach notification policies. So there were requirements to implement policies and procedures to reasonably protect against unauthorized use and disclosures, and have, the various physical security and other safeguards. But they didn't have the very strict breach notification provisions that were included in HIPAA, which include, disclosing to potentially HHS, affected individuals, and in certain circumstances, the media. There's very few providers that, are treating 500 patients at a time, but HIPAA has a 500 patient threshold. So, if there is a data hack, or, I think I've heard in all healthcare industries, just the cybersecurity breaches, that could potentially apply to some of these smaller programs, over the course of their history of treating patients. So HHS would be permitted to apply the breach notification rule and obligations to any person who receives SUD records that were unauthorized to receive those. Right, moving on to the uses and disclosures without patient consent. Currently, Part 2 permits the disclosures of Part 2 records without patient consent in very narrowly tailored circumstances. I kind of listed a few in one of our previous slides, but just as a refresher, medical emergencies, scientific research, or furtherance of an audit, if they have a valid court order, or very specific police reporting purposes. But the proposed rule alters the audit exception to allow for management audits, financial audits, and program evaluation, and adds a fourth circumstance in which disclosures may be made without patient consent for public health purposes, which is a clear connection to the CARES Act and COVID-19, when they found that they were not able to share records for public health reporting purposes, which certainly patients in 2020 and 2021 and 2022, and still, experiencing COVID outbreaks, the public health officials need to be aware of those and be able to track that, just like they were every other healthcare facility and other healthcare settings. So this was a positive change that previously was a challenge to get that information. Part 2 does not have the same standard for de-identified information as HIPAA, and this is an area that HHS proposed in this rule to kind of create that same standard. I think that this is, again, not something that people are thinking about on an everyday basis, but certainly I see this in the litigation world where people are selectively choosing what to share and what not to share, and we may not always have the same understanding of those definitions. So any alignment that we can do just to be more consistent with other very commonly known laws and regulations, I think is a very positive change. Moving on to our discussion about patient rights after great questions. The proposed rule codifies several new rights and protections for patients under Part 2. The first two are pretty explicit rights that they are incorporating into the regulations: the right to request restrictions on disclosures of their records for the treatment, payment, and healthcare operations purposes, and to restrict disclosures to health plans for those services paid in full by the patient. Those are, direct correlations from HIPAA that they want to incorporate if they are allowing the patient to create a consent that would, go beyond just what they originally contemplated. So that's just kind of, putting a right for the patient to kind of uphold their original choices. the right to receive an accounting of disclosures for their Part 2 records for the prior 3 years. Again, this is straight from HIPAA that just allows them to see how their information has been used. That accounting of disclosures piece is certainly something that will take some provider adoption, because while sometimes they're sending it out of their EHRs and that can, track some of that information, sometimes the provider's doing it themselves, and that may not always be caught just from that setting. So, that's certainly something that's going to need some technical and kind of administrative procedures going forward. Third, the right to file, and then the kind of conversely, the programs establish a process to receive complaints about Part 2 violations. Kind of going on with breach and notification requirements, have to have a meaningful way to receive those notifications by the patients and anyone else. And then expanded protections on the use of Part 2 recordings of Part 2 records in legal proceedings without a court order or patient consent. So that's kind of a follow-up, and I'm happy to circulate that stuff with everyone or have it disseminated following this. Qualified service organizations, touched on that briefly. Currently, Part 2 requires explicit written consent from an individual before a program can disclose information to a qualified service organization, unless the Part 2 program have a QSOA in place. And that's just it's similar to a business associate agreement. And this change that they are proposing to make would align the business associate requirements with the qualified service organization requirements, which would just eliminate needs for paperwork that half the time people don't know exist. So I think that that's a pretty simple change. Moving to enforcement. Enforcement has been an area that has really been lacking in Part 2. We just have really lacked the kind of authority to kind of ferret out the bad actors, and not that anyone necessarily intends to disclose things improperly, but sometimes that does happen, and certainly we want to have a process that enforces compliance with these rules. So they are working to really enhance the enforcement provisions. HHS would kind of step in to have an authority to enforce it, and violations would be referred to the Secretary of HHS, kind of similar to OCR, which enforces HIPAA. Enforcement of the rule would kind of come certainly an extended amount of time after the final rule is published. So we're not even there yet. So nothing to worry about currently, but 22 months from the publication of the final rule to come into compliance with the revised standards, and then enforcement 24 months after. So, at a minimum, we're looking at May 24th of 2025 before we get anywhere near having to worry about the ultimate compliance, but that's certainly something that's coming. The notice of privacy practices is another kind of remnant from HIPAA that they are trying to incorporate into Part 2. I think, again, anytime you can have an opportunity to let patients know what's happening with their information is a positive change, but certainly not something that our providers are accustomed to providing their patients right now, unless they are having other kind of HIPAA operations within their entity. So certainly smaller providers may not be accustomed to having this in their kind of front end packets. The proposed rule it would modify the HIPAA requirement to require that they have a provision limiting the redisclosure of SUD records. That's something that has been part of Part 2 for a long time. It used to be this paragraph notice that they were limited. They were prohibited from redisclosure, and now it's just like a one sentence little small notice that that says these records are prohibited from being redisclosed. So they've updated that considerably, but certainly understanding the limits of that is something that not all providers may understand. So just some like high level impacts of these changes, kind of summarizing the things that we've kind of discussed. Providers are going to be able to more effectively share information about patients after they receive an initial consent. Stakeholders have been pushing for an alignment of HIPAA and Part 2 for many years. I think that the changes that they've made so far with these proposed rules get a lot of the way. I think that there's certainly areas for further alignment, and just kind of the definition of records and how Part 2 even applies still leaves a lot of questions, which providers are kind of left to deal with themselves. Typically, HIPAA is so much more universally understood. There's certainly questions, but kind of having these two laws kind of juxtaposed with even slightly different requirements will continue to be something that people have to keep me in business for, I guess. I'm not going to try to talk myself out of a job, but certainly something that allows for continued questions and continued legal change down the road. I think that enforcement is going to be an area that will be a challenge. I think anytime you kind of apply a new kind of framework to an entity, while HHS has been doing some of this for other kind of groups of providers, certainly adding this in is going to be tough, and kind of getting the universal kind of compliance with the new requirements is something that's going to be a challenge. Some provider groups and patient advocates are concerned that some of the relaxing of the standards around patient consent could erode the framework that really made Part 2 what it is, and that even this will impact access to treatment because patients will be scared that their records may be disclosed to their employers or someone that they just don't want to have treatment or want access to their records or know that they were receiving care for valid reasons. And I think that that's certainly something that will need to be kind of continuously part of the discussion, because we want to encourage people to get the care that they need. And so anytime that that's being impacted, we need to be aware of that. But certainly we want to be mindful of that in this kind of day and age where it makes sense for providers to generally be aware of the type of care that you're receiving that might impact your future prescribing habits. And it's ultimately the goal is to provide the patients with the best possible care. And so I think that we have to kind of be mindful of that. Certainly, as someone that deals with insurance reimbursement and helping providers get paid for that, in this day and age, the provider audit is a tool that payers use as a weapon. And so I think that some of these changes will make it easier for payers to get data, which previously, I've worked with providers trying to resist some of these audits and enter into very specific audit agreements so that payers are limited in how they use the data. Some of these changes may make it more difficult for providers to protect themselves from some of those types of data review, which, could have an impact on providers down the road as well. So just something to kind of be considerate of as we move into this kind of next phase of rulemaking and regulating. The CARES Act included an anti-discrimination protection, which HHS didn't issue regulations on in this kind of go around. So that's something that I'm interested in seeing how they address that going forward. But I think that, again, this is certainly an area that we want to protect individuals from being discriminated against, and just creating additional protections for patients and encouraging them to seek treatment. Some of the key takeaways for providers and, provider advocates and others in the industry, providers are going to be subject to, enhanced requirements, specifically around the new patient rights and the restrictions on disclosures and the disclosures of records for treatment payment and healthcare operations purposes. They're going to need to be prepared to update their consent and the notice of privacy practices with their patients. And begin to evaluate how to implement the enhanced security measures, policies, and procedures to address the security and breach notification requirements. And they're going to need to develop internal policies and procedures for reporting violations of Part 2. So that's a lot for them to do, but I think knowing that they have 22 months to kind of get there, I think that that's going to be imperative. I think that certainly these are not final rules, these are proposed rules. My sense is that they are not really wanting to change what they've got, but certainly, hopefully, the comments that they received will have some minor changes to, kind of hopefully smooth out some of the definition problems that we're seeing, and potentially alleviate some of the other kind of questions that are still kind of out there. But generally speaking, I think that these are positive changes that, are going to ultimately kind of lead to more interoperability and kind of fewer burdens for data use and data sharing. All right. I'm happy to answer any questions. We have about 15 minutes, so I'm happy to field that for the rest of the time if you guys have any kind of follow-up questions.
Hey, Nicole, thank you again for your time.